All right, everybody. Again, good morning. Huge appreciation for you being willing to take this cold Monday morning and take advantage of some quality education. One of the busiest people I know, Griffin Dunham, also took his time to provide it for us. So I want to say thank you to Griffin for sure. If you're not taking advantage of Momentum Title and the support that they offer us here at Benchmark, I firmly believe you're making a huge mistake and providing a huge disservice to your clients. Not only because the cost savings to your client, but the knowledge base that this team brings to the table and the support that they give us. And I want to make sure that we support them back all that we can. So with that, I'll be quiet, let Griffin take over, and everybody have a great day.
Thanks, Scott. Very much appreciate it. Good morning to everybody. Hope everyone's survived the last week. I know it's difficult, and for a lot of people, some people might not even have electricity that's readily accessible. So thank you all for being able to join this morning, and also congratulations to all who have been able to successfully survive here. I'm going to start off by sharing screen, and let's see if this will work. Not turned on, so just send the request. So Scott just sent you a request to allow for the screen to be shared, if you wouldn't mind granting that.
I got you.
Alrighty.
I also want to share with all benchmarkians, just in the meantime, feel free to use the Q&A feature. Here we don't have a chat rolling, but Q&A is there and we can pass any questions along to Griffin if needed.
Great. Able to share. Let's see here. Let's make sure that this is showing up as on your side. Katie, Scott, can everyone just make sure? Can you confirm that you see the slide deck here on the screen
Yes,
now?
we can see it. You're not in presenter view yet, but yep.
All right.
Good to go.
Presenter view now. All right, so big picture, we have an hour here. The goal here is not to educate anybody on how to become title experts, how to become processors, or understand what people do on our side every day to get the documents to closing. That would be like if you were to present to us how to be a real estate agent. Brains can only fit so much information, there's only so much time. So the 2.5 years that it takes from not knowing title to becoming a processor, in the years of going to law school to learn about real estate law and then to practice it, can't really condense those down into a 1 hour segment. Instead, the goal is to make this about what do you need to know in order to be an agent. If you want to go to a cocktail party and speak intelligently about title, which I would not recommend to anybody, but if you do, then the goal here is to make sure that you can at least have that conversation if you want to. Mainly, the goal is to be able to talk to your clients about the title process so that they have questions. You don't have to feel like you're letting them down by not being able to answer their questions right away or by not having a resource to be able to go and find out what those answers are. We always want to seem educated, we always want to seem knowledgeable, and we always want to come across as being credible. The best ways to do that are to have the knowledge that you need, that I consider to be the basics about the title process, because as you know, there are many processes. There's an inspection process, there's a final walkthrough process, there is an appraisal process and work with lenders, there's working with the title company, there's oftentimes working with the other agent who's involved. You name it, there are a lot of processes. The goal here is not to make you an expert on title. The goal here is to make you appear as though you're an expert in the eyes of your client. So here's what we're going to be covering today. It's a lot, but we're going to go kind of fast through each one of these. Mainly, the goal is to, if you can't remember it or can't absorb it completely, the slides are going to be made available. And then also you can always reach back out to us. Everybody's going to get a copy of this. So I wouldn't be too concerned about taking notes right now. So you can always take notes when you get it. What we're going to cover: what is title? What is it not? What are the title rates? Because we get a lot of questions about whether or not the rates are going to fluctuate depending upon what county it's in and depending upon who the title agent is. How do we handle earnest money? Pretty simple and straightforward, just one slide on that. And then what we kind of go through as part of the title clearing process. This is the one slide that is the most about what we do. And it's really just so that you understand and can talk to your clients. If you're talking to the process, you're going through the process, they're not just speaking words, they're actually saying things that will make sense if you know the process fully. What is the title commitment? We've heard a lot about the title commitment. We've heard a lot about the title policies. but what is the title commitment and why is it something that you should consider reviewing every single file? What can you do to delay your closing? Of course, you don't want to. You want to prevent the delays. And so, what are you doing that might cause delays, and what are you not doing that might cause delays? And then fraud detection platform. We all know fraud is everywhere. We're going to cover what the different programs and profiles and the platforms are, and also why it's so important. This is one of the pain points that clients have is that they feel like they have to validate who they are. And that's because they have to validate who they are in order for the title underwriters and also for the title agents to make sure that there's no fraud involved and to make sure that people's money is being protected. At the end of the day, there's a lot of money that is going back and forth taking 5 minutes, taking 7 minutes, which is the average time that it takes to go through fraud detection, taking that 7 minutes is absolutely worth it. And it's for everyone's benefit, and not just theirs, it's for every party who's involved. And then lastly, it's how to prepare your clients for that closing. We're also going to just briefly run through a settlement statement, but I just want to put that in there so you can hear me just run through it so that you can be able to at least understand what's part of every title, every settlement statement. All right, so first of all, what's title insurance? Title insurance is completely different than other insurance that you think about. If you get insurance for your car, what is that doing? That is determining that there is a future likelihood of a risk, and then you are paying money so that in the event that that risk turns into reality, that there is coverage. There is someone who serves as a surety who can step in and then satisfy any claim that results from the risk that occurred in the future based on a lot of algorithms and a lot of driver profiles. For example, in the vehicle world, how many accidents have you had? What zip code do you live in? How many miles are you going to be traveling a year? What kind of vehicle that you have? All those go into determining how much your rates are going to be based on the likelihood that you might get into an accident in the future. Insurance for title is completely different. It's the opposite. It is not looking forward about what risks might occur. It's looking into the past to determine the likelihood that a future risk will result in a claim. So the odd thing about title is that this is a very common misconception, that the title process by closing, it guarantees that a party has good and marketable title to the property. That's not what title insurance does. If you recall from the contract, one of the requirements to close is that it's clear, marketable, and insurable title. So the insurance side then looks at a property, determines what the risk is that that's going to result in a future claim based on what's happened in the past, and then they issue a title policy, not guaranteeing that the buyer that there is clear and marketable title, but it's guaranteeing to the buyer that there's going to be a risk that's going to be covered in the event of a loss. So insurance companies, well, there are not too many properties out there that have a 0.00% chance that there's ever going to have a claim filed that there could be some problem with the chain of title. But that's okay because it's such a low risk that the insurance company is willing to insure, despite the fact that there could be an adverse defect in the chain of title. That's what the business is all about. That's insurance, is that you don't know what's going to happen in the future, but you look at the risk, you assess the risk, and then you determine if you're going to insure over it. So that's the first thing that a lot of buyers don't quite understand, is that the title company doesn't guarantee that there's clear and marketable title. They guarantee that there's going to be coverage if there's not. So by the way, if I'm explaining title insurance to a client, I keep it pretty simple. I summarize what I just said, but I say title insurance, there is a long history of your property. It dates back since our country first existed and before. There have been a lot of different owners, and there have been a lot of different events that have occurred on that property. Title insurance looks at everything that's been publicly recorded from the closing date backwards to determine the likelihood and the risk that you're ever going to be deemed to not be the sole and exclusive owner of this property without any defects, liens, or encumbrances that could affect your ability to quietly enjoy your property. And try to keep it simple and just say, so that when at closing date, when you're paying for a title policy, you're paying for insurance so that in the future, after you own the property, if there's ever a loss on your part, if you don't own the property, if there is an easement that affects your property that was publicly recorded, then you're going to have coverage that the insurance company will compensate you for the loss of that quiet enjoyment of your property. Try to keep it pretty simple. The next topic is that of title rates. This is a common one too, is that Title rates are pretty much the same across the board. It doesn't matter where your title agent is located. It doesn't matter who your title agent is. Take some of the other title companies. Let's just call some of the big ones. You have your large institutional national title companies. You have your regional title companies. We write both in Kentucky and Tennessee. Then you have your local ones where some title agents don't even go outside their county for the most part. It doesn't matter who is writing a policy because the Department of Commerce and Insurance sets the rates for title policies, and that's based on what the underwriters have supplied to the Department of Commerce and Insurance. So if the underwriter is going to supply what their rates are for refinances and for a loan policy and for an owner's policy, then those rates are submitted. Once approved, and then they get pushed out to the community from the Department of Commerce and Insurance, and that's what rate has to be applied at closing for that underwriter. So given the fact that all these different underwriters have to publish their rates, it's effectively a very efficient market, near perfect market. And if it's a near perfect market, all these underwriters are going to be competing against each other to provide the best rates, because if they don't, then the agents are going to flow to using those other underwriters, and the market is going to respond by wanting the best price for that product, the ultimate product being the title policy. It's what we're in the business of doing. We're not in the business of clearing title. We're in the business of issuing a title policy, because even if we don't clear title, that's okay. It just comes down to it being an insurable risk. So the rates are the same. When I say the same, I don't mean exactly the same. I mean, it doesn't matter if you close a property in Johnson City or if you close a property in Shelby County. The rates are going to be set by the Department of Commerce and Insurance, so they're going to be the same no matter where you close. An agent, a title agent, cannot get you a better deal in Nashville. There's no title agent in Nashville that's going to get you a better deal than Momentum. And I hate to say it, but Momentum's not going to get you a better deal than any other title agent. Why? It's because the rates have already been predetermined. If you ever want to know how it is to find out what those rates are, you can see here, this is our website, momentumtitletn.com. Right here at the very bottom on the right is a little widget. And if you click on that, that's going to allow you to create your own net sheet and also title estimate for closing cost. This is, if you click on that button right here, this is where it comes to. You enter your location, and then you start going through and entering sales price, loan amount, who's paying for title, and then it is going to have the ability to email you directly that title quote, which includes not just the government recording and transfer charges, like recording the deed of trust, but it's going to include what the rates are for the title policies. And it's going to include what the settlement fee is going to be, at least for on our website, it's going to be our settlement fee. So it'll give you a nice snapshot of all your closing costs that are related to title. It's not going to include tax prorations or adjustments. You can get that through a net sheet, but it's going to include the basics as to what the title related costs are going to be. I mentioned that there are title policies. One quick note, there are two types of policies that are issued in most transactions. If it's a finance transaction through a typical institutional lender, that lender is going to require there to be a loan policy. It's not a lender's policy, it's called a loan policy. The lender is going to have a loan policy in the amount of the loan. So in the event there's a title defect and their borrower does not actually own that property, or there is a claim against the property to show a higher priority lien, or there is a claim against the property that results in the property being depreciated after this known defect is realized, well, the lender is then going to be insecure, and they want to make sure that they have coverage so that that borrower then defaults under the loan because they're not the owner. They can no longer afford the property based on some other claim that's being made. The lender can go to the title company and say, you gave us a loan policy that covered this risk. We're now going to file a claim so that you can pay us for our loss that we incurred because we now have a non-performing borrower. So that's the contract between the title company and the lender. There's direct privity between those two. The owner has no say in what the lender can or can't do under the policy because that borrower is not a party in interest to that contract. You can't assert an interest. You don't have the standing to assert an interest in a contract that you're not a party of unless you're a named third-party beneficiary, which borrowers are not, owners are not on the loan policy side. But that's okay because an owner's policy then covers the difference between, well, one, the owner's policy is going to be issued in the sales price. So the face value of that of the policy is going to be the sale price. So if you have a $500,000 property and you put $400,000 down, well, your loan policy is only going to be for $100,000. Any owner should not feel comfortable when there's only coverage up to $100,000 for that lender, and then they're exposed for the other $400,000 between the value of the loan and the value of the property. So we have the owner's policy, which then is a contract just like the lenders that are getting the title policy. They have their loan policy. Just like the lender has privity with the title agent, the owner has privity with the title agent, where the lender can't step in and have any benefits from that contract. That's just one between title agent and the insured, the buyer, who is getting the owner's policy so that they can have coverage up to the value of the property. So if I'm looking at a property issuing title insurance to that borrower $500,000, and it turns out that 2 owners ago that there was an estate, someone had passed away, and not all the parties had signed. In fact, only one party signed when there should have been a lot more parties signed. Well, all the parties who didn't sign are actually the owners of that property still because they never transferred away their interest. So if all those different owners were to then step in to say, this new buyer doesn't own the property, we own the property. And so if it's 4/5 of $500,000, so 4 people of the 5 who were supposed to sign didn't sign. Well, now all of a sudden, the new owner that we provided a title policy to only has a $100,000 value ownership interest, and they would be hurt by $400,000. They'd file a claim saying these other 4 people actually own this property, and it's not. I only own 1/5 of that because only one person signed before. I'm filing a claim. Well, in that situation, the title policy should then benefit the owner by the underwriter and the title agent writing a check for $400,000 to compensate that buyer for the risk. So those are the 2 types of policies, your loan policy and your owner policy. They work together, but they're for completely different beneficiaries, different insured, and then different rights under each of the different policies. So that's the primer on title rates. For those that don't know, there are a lot of platforms now that do this. We use Earnest, but if your clients ever want to make the payment of earnest money simple, easiest way to do that is just by going online, never getting out of your pajamas, and just doing it via ACH. It's safe, it's secure. These parties have been in business for a long time now, and they have a lot of security on their side. So it's simply a matter of going onto the website, clicking Earnest, and it takes you to the portal so that you can put in your information, and then within a matter of seconds, then that payment gets delivered. It clears 1 or 2 days later. Does it cost a little bit? Yeah, it's like $18 per transaction now. So prices have gone up. They do fluctuate quite a bit. So whenever you're listening to this, if it's in the future, I don't think it'll be $18 in the future. In fact, they seem to change quite a bit. But just know that that's a lot easier than writing a check, driving across town just to drop it off to the holder of the earnest money when you can do it all online. So a lot of people do take advantage of it. Over 70% of our earnest money comes from ACH through Earnest. So it's simple, takes 5 minutes. It's a heck of a lot easier than getting a check and driving it over. The title process, let's talk about this. And this is one where I said I don't want to get too much into the weeds about what it is that we do, but I do think it's important to at least understand what the sequence of events is that title agents are always going to use their protocols to advance the process forward. And this is just a simple breakdown of a 4-week timeline. You have, and I think these numbers are wrong, and of course, you're using the standard benchmark contract, which hopefully you are, then this needs to be replaced with those line items for the benchmark contract, which is I think a great product and one that everybody should be using, preferable over the bar form. So if we're on this contract, so in this situation, we were on the contract, you as the agent, you just can't put it in pipeline. A lot of people think that we have access to pipeline. We do not. And so if you just put it in pipeline, you'll never get it. We have an email address called orders@momentumtitletn.com. You send the contract to orders@momentumtitletn, and that starts the process. We have someone on the intake side who takes that contract and then looks at every single detail. So every field that you can fill in, then we lay eyes on what those fields are, how much the earnest money is, what the property address is, what the parcel ID is, of course, all the different names of those who are involved to include the agents, what your closing date is, who's paying for title, look at the special stipulations. Those are all fields that we then start to put into our software processing platform. So that information goes in. Once all that information goes in, then from an automated standpoint, our system then will just go into direct an email to your clients that you can or cannot be copied on, whatever you prefer. And that's going to be an information request. They have to put in their information. They have to put in their bank account information if they're on the seller side. They have to put in their information on the buyer side as to how they're going to be vesting title. It's basically all the things that we would want to know about you as a seller or a buyer in order to process the transaction. So once we get that contract and we put it in and that information goes out, keep in mind, we don't necessarily order a title search on that day. We order a title search typically after you pass inspections. Because if we have a 12 or 15% fallout rate on contracts, every time we order a title search, let's just say that it costs us $125. It depends, won't get into it, but there are all-inclusive counties and then not all-inclusive counties and different there are some different counties that have different fees that are associated with it. But in general, let's just say that costs $125. If we're doing 200 plus closings a month with a 12% fallout rate, we would be spending far too much money on title searches that never went to closing. As a standard practice, I'm not aware of any title agent that goes directly to a buyer or seller and tries to get recoupment. Instead, every agent just eats that as the cost of doing business. So naturally, they want to wait as long as they can and get through the major hurdle of the inspection before they order the title search. It's not always the case. If you have a closing that's 2 weeks away, so from the time that we get the contract, if there's a closing that's in 2 weeks, you don't have time. You don't have the benefit of waiting to order the title search. You have to order it right now and just hope. But if you have a contract that's 45 days out, don't be surprised if title doesn't order the search until after that inspection deadline that we see in the contract as to what that is before it gets ordered. If there's a special occasion, though, where you say, we're really concerned about XYZ, we know that this is an issue, we're going to have to jump on this issue quickly. One, if you're on the seller side, hopefully that would have been something that would have been brought up before so we can start doing the work before we go under contract. But if not, that's when you just have a conversation with the title agent to say, can you order the search right away? Because we think there might be some issues here. So that's one of the ways that gets around that. So after the search comes back, then we have our processor who receives it, and then the title commitment, which I won't be able to show. We're going to get to that. Let's just go ahead and jump in it, and I'll go back. Here's the title commitment. Here's part of it. So it's a long document. It's not that, I shouldn't say it's a long document. Call it 8 pages. And the title commitment is one that comes from the underwriter, and every underwriter outsources the searches, and so do we as title agents. We're not in the business of conducting title searches. We don't do those. No title agent does those. At least they shouldn't for exposure limitation. So when we order the search, we're going out to a provider, and sometimes underwriters will use people in Pakistan and in India, and they're not familiar with some of the nuances that we have locally, and so we get a title commitment back. And there are some things on there that are head scratchers, and we find out that these outsourced searches are one that were relied upon, and then we just make sure we never use that again if they're deficient. But the searches get outsourced, and then the title searcher will give us back the search results, which could be a 30-page document or it could be a 150-page document. The title search is what goes through the tax records. It goes through everything that's been recorded with the register of deeds that affects that property. It shows the prior deeds of trust. If it's in a subdivision, it shows the declarations, covenants, conditions, restrictions. It'll show any bankruptcies that have been recorded. It'll show judgment liens. So depending upon how complicated the chain of title is, that could be a very long document or it could be a short document. One thing to keep in mind, that's your clients if they want it. As a practice, we don't send the search results to any borrower or any seller. And we don't do that because one, a lot of times they wouldn't know what they're looking at, for one. And two, even if they look at it and they think it's fun bedtime reading, if there's insurable title, then they have to close. So it doesn't give them ability to terminate the contract. The content of the title search does not give any buyer or seller any rights under the contract, because the rights under the contract are then limited to whether or not the seller is able to pass insurable title to the buyer. However, you can see these, and so can your buyer, so can your seller. They paid for them as part of the title search, and so they can get those. If you ever want one, by all means. Clients do get every single time the title commitment. And the title commitment is one that contains a lot of things. It defines what a covered risk is. It defines what is excluded. and what's exempted from coverage. But it also includes requirements. In other words, the requirements are the things that the title agent has to accomplish before closing. And so I just included this screenshot here of a typical commitment. The first one here is make sure that the only those and people who are going to be the insured are the ones who are going to be included with the title company. I won't get into. I'm trying to avoid going too deep into any of these topics individually. But when I'm talking about the chain of title defects, when we have a long search that has judgment liens or has prior deeds of trust from the seller who hasn't paid off their mortgage yet, no problem with those. But this is where they start coming in here at number 5. So these are just standard. They're everyone. And so this one here, payment cancellation of a deed of trust. Well, if there was a judgment lien would be down here at number 6. Number 7 was make sure that this person is not one and the same as the person who filed for bankruptcy. So make sure that this requirement now is telling us this is what you have to do to clear title. So we get a commitment, which you can also see in which your clients are going to see every single time as part of the automations in our processing platform. This summarizes what the title search is. So the title search has everything that happened in the chain of title. The title commitment is a summary of that. And so we provide the summary so that if they have questions about the deed of trust, they don't have to look at page 134 of a title search. They can see by on this one page, number 5, is, hey, what's that deed of trust right there? What is that you're referring to? And then we can have a discussion about what the title commitment is. But that commitment is what commits the underwriter to provide insurance to the buyer. And so a policy that is usually received 60 days after closing, the policy is going to reflect, and it's going to perfectly dovetail and mirror what's in the title commitment, unless there are endorsements or exceptions that typically don't apply. But this is what you're giving to a buyer to say, you're getting a title policy, and here are the requirements that the agent has to go through in order for you to get that policy. There are going to be exclusions from coverage, things that are a matter of public record, and it shows the buyer right there before they ever get to closing what the coverages are of their insurance policy. Of course, no one's going to issue a policy without letting the insured know what the limitations and coverages are on the policy, and that's what the title commitment does. So your clients get those. If you ever want to see one, by all means, knock yourself out. Let us know. We'll let you see every one of them. Settlement statement. Let's just briefly go through a settlement statement because it's on the title side. We prepare a settlement statement, and that settlement statement then is what you get to review and pass along to your client, ask questions about them. So it's itemized. It shows the entire financial nature of the transactions here. And so here's your settlement statement. You've already seen these many times. But just keep in mind, top section here, the primary charges and credits, those are also called financial costs. Typically, it just includes sales price, what the earnest money is, any lender credit, and then any seller credit. See those on both sides. And prorations and adjustments, you only pay for property taxes for the period of time that you own the property, bottom line. So that's what these prorations are. It's from it depends. If the tax bills have come out, keep this in mind, tax bills come out mid-October. Before the tax bills come out, those taxes that have accrued but are unknown because the bills haven't come out yet, that constitutes a lien that's not yet due and payable. So if the tax bills have not come out, in this situation, the closing was on May 19th, 2023. So in that situation, the tax bills had not come out yet, so it's a seller debit. The seller is paying the buyer $720.02 because that's the estimated amount of taxes that have accrued between January 1st and May 19th, 2023 for this year. So the buyer cannot pay those right away. If the buyer could pay those right away, then the seller would have just paid those, would have contributed to the taxing authority, and then there would be a different breakdown on the settlement statement. But sellers cannot pay them because they're not a lien that's yet due and payable. So instead, the seller is debited, gives that money to the buyer at closing, so that then it reduces the buyer's cash to close because the buyer is presumptively going to be in a finance transaction. If not, then the buyer would just get that money at closing to reduce the cash to close. And then the buyer would know when the tax bills do come out that the seller has already contributed their portion of the ownership period and then they're going to be responsible. The buyers are going to be responsible for the entire year. It's flipped. If it's after October 15th or so, if it's after tax bills have come out, then the seller pays for the whole year of property taxes. So if this situation, if the tax bill came out on May 18th, which does not happen, but if it came out on May 18th, then you'd have a seller credit and a buyer debit for the amount of taxes that accrued from May the 18th until the end of the year, because that tax bill is going to show that the whole year is now being owed. So the seller is going to have a credit here for the prorated amount from May 19th to the end of the year, and then down below on the next page, the miscellaneous charges. This is where the seller would pay for the entire year of the taxes. So in pounds, for what it's worth, these lender fees, they always are going to collect for insurance and for property taxes in the event that a borrower doesn't pay under the promissory note. The lender wants that extra security there so that they can make sure that their taxes are being paid, the insurance is being paid, so the property is not subjected to any depreciation since they have an interest in the collateral as a lien with the deed of trust. The aggregate adjustment is pretty common. We get questions about this. They think that the lender's up to something that's no good. That's not the case at all. If lenders exceed the threshold that they can collect for homeowners insurance and for taxes, they have to give an aggregate adjustment back to the buyer so that they can be in compliance. So here they took too much for insurance and taxes in the amount of 538, so they just give that back to the buyer as a credit. If you ever wondered what that is, it's just the lender exceeding the amount that they can withhold under federal regulations. Payoffs and payments, pretty simple. Just whatever the mortgages that the borrower has or the seller has to be paid off at closing. We have a couple of them here. And then the recording and transfer charges here. These are always going to be buyer expenses. It's just the amount that the county charges to record the deed and to record the deed of trust. It's a pass through. There's no markup on any of these. And so that's where you have the government getting what they're due. Sellers typically still pay for commission, not always, or sometimes it's split, but you can see here that's the seller side. You're all very familiar with that one. Title charge, you can just see here at a glance that the buyer is paying for title. So remember this rate right here, what we were talking about earlier, the title policy rate to WFG, National Title Insurance Company. We don't use them anymore. Our two are First American and Fidelity, two of the biggest. Since they're the biggest, they just seem to always just provide a superior product, at least for our needs. But you see here that the owner's policy is $84 and the loan policy is I don't know why it says lender's title policy. Okay, we didn't draft this. We just got it, but it should say loan policy. Anyway, so you can see those two amounts are set by the Department of Commerce and Insurance. One quick thing, people are always wondering, why are those are so different right there. Remember our post from a few weeks ago if you haven't seen it. These amounts don't go writing on your contract, buyer to pay for owner's policy, seller to pay for the loan policy, or the owner flip-flop them, doesn't matter. Because if you're used to seeing a very low rate for owner's policy and then you're seeing a high rate for the loan policy, keep in mind there are different ways that title agents are instructed to be able to calculate who's paying for which of those policies. So just write on there, if you want to get the lower of the two, then write in your contract, seller to pay for the lower cost of loan policy or owner's policy. Whoa. And then buyer to pay for the higher amount of the two policies. But anyway, the reason that these two are different is because simultaneous issue applies in Tennessee. It's when you're issuing two policies at the same time for the same property. Then they get the benefit of the simultaneous issue, which is a credit there. So if you see these wildly differing numbers here, that's oftentimes a product of, it's always a product of simultaneous issue, and it's going to be based on what the loan amount is and how much coverage is still going to be required for the owner to get from the loan amount up to the purchase price. So very common to see these because simultaneous issue, these two numbers, $22.74 and $84, that's consistent with simultaneous issue. And then also keep in mind that the loan policy is always going to be higher if it's a typical finance transaction where only one party is paying for both policies. But that could be different if you have one party paying for one policy, another party paying for another policy. That's why you should never list which party is going to be paying for the owner's policy or the loan policy. Just state which one's higher or lower. Then you can see here, 250 on each side is our settlement fee. I want to mention this because this is where your settlement fees are typically included. We got both sides of this deal. In other words, we close buyer and seller. And so since we close buyer and seller, we discount our settlement fee. Settlement fees have gone up to 550, so it's 275 per side. One thing the title companies are doing that I don't love is that, and you should look out for this, is that they ask us, what's your settlement fee? And we say, well, it's 550. And they then go and they compare that to other title companies. Other title companies will say then our settlement fee is 500. So they can deliver on a $500 settlement fee, but then they get to closing and then there's an electronic storage fee for $400, an exam review fee for $500, or there's a document review and preparation fee for $300. It's a disguised way of having their fees. The talk is settlement fee. What's your settlement fee? And so they can accurately and truthfully say this is our settlement fee, but they don't tell you what the other fees are that they're going to tack on to closing. Just make sure that when you're talking to any title company, hopefully use us because we don't try to disguise what our fees are and are not. Just ask us what the different fees that are going to be at closing from the title company, because that's where title companies make their money, from the settlement fee and then from the commission off of issuing the insurance policy. So the settlement fee is a big one, and the other fees, if they're not part of these right here, there's only one fee that's typically on there that's not, and that's a courier fee. Since we got both sides on this transaction, we didn't have to use a courier. And so there's going to be a $75 fee. Most title companies are going to charge some fee. The amounts might vary, but you have to have a courier. You have to have sometimes overnight FedEx. You have to have different charges for recording, and then just the transportation cost of getting things somewhere. Those are considered to be out of pocket, and also the fraud detection platforms. So those other fees, just keep in mind though that you should ask your title company, what are your settlement fees? And not just your settlement fees, what other fees do you also charge? So miscellaneous, these are pretty straightforward. Here are your default closing costs. These are pulled from the contract. Just keep these in mind. I'm not going to spend much time talking about them, but this is what the contract defaults to as to who's paying for what. And this is where it's listed here in the contract, but that's the old contract, so we can care about anymore. What can delay your closing? So the things that you should be talking about to your clients before you even go under contract is if it's on the seller side, especially buyer side, these really don't matter too often, because buyers aren't the bankruptcies do matter for a buyer, but oftentimes buyers in bankruptcy aren't the ones who are able to finance a home. So these are typically for sellers, and that's that if there's a bankruptcy in the past, if there's been a divorce that is either pending or is recent, if there is an estate file so that your owner of the property is not on title because the person on title has passed away, and there's either probate or there's not. That's where you get ahead of it. You contact the title company before you even go under contract. If you're on the seller side, you ask them these conversations, you have these conversations with them about whether or not there's anything in the past that can affect the title. And you can do it delicately. You can say, there are some things that I have to do to protect you. My number one goal at all times is to protect you. There's nothing I can do to jeopardize that ever. And so there's a couple things that I have to ask you about, and they can be awkward for some people, but they're not intended to be. Again, the goal is to protect you. So I have to ask you a few things, because if I don't, then there's a chance that we're going to have problems selling your property. And whatever I'm asking, we think we're going to be able to get over it, but we just have to know a few things because our title company is going to ask for those. And since they're going to ask for those in the future, let's just go ahead and get in front of it now so we can avoid any delays and any problems. And those are, have you ever had any bankruptcies on your in your past? If so, not a problem. You just have to know it. And then go through and talk about some of the more painful topics here. Payoffs are one where it's typically not a problem. If you have your Rocket Mortgages, your United Wholesale Mortgage, they love to give payoffs because they know they're going to get paid in full. Other types of odd mortgage companies, the smaller ones, or the ones that can never get somebody on the phone, sometimes they can be hard to get payoffs from. Now, we can't take a seller's payoff statement because those could be fraudulent. It's pretty easy nowadays through AI to change numbers around and have it look professional and legitimate. So we have to get that information directly from the lender. But it's a good idea for them to at least have an idea as to who they owe money to. And also, what I should put on here is unknown judgments. So the seller knows that they're if they've been a defendant and they have a judgment against them. But that's one thing that you should also ask is whether or not there are any judgments that are out there. That is a little bit less concern. I didn't put it on there because as part of a title search, we'll find any judgments. But we also find payoffs. It's just a matter of trying to get those payoffs to be received. So just make sure that they're aware that they have their lender information so we can request the payoff from the right party. And then these uncleared liens and encumbrances, that's where a judgment lien would come in, but any other lien too. Mechanics lien, somebody put in HVAC and didn't pay for it. It's important to at least have them know what the extent of the liens and encumbrances are. So before we even go under contract on the title side, we can even start working to make sure we know what those payouts are going to be. Fraud detection and prevention. I sure I'm doing okay on time.
Oh, you muted.
Is that better?
Yes.
So fraud detection and prevention, we mentioned earlier fraud is everywhere, and it really is. It's on the buyer side too. It's on the seller side. It's not just vacant land anymore. Just a few weeks ago, we got from another title company, we got a payoff for their seller. And the payoff came from Mr. Cooper. And the payoff, when we looked at who the beneficiary was, it said something like Payoff Processing Fund LLC. And our processor, who's closed a lot of Mr. Cooper loans, said, Payoff Processing Fund LLC. I'm not familiar with that. That's odd. That's something that we don't typically see. Now, we issued a check to Mr. Cooper, so this was avoided. Any problem was avoided. But she was curious and she said, we contacted the other title company and said, this payoff is to Payoff Processing Fund. All of our other payoffs to Mr. Cooper are going to Mr. Cooper. And so the other title company said, yeah, it's good. We got that via fax. And so processor just contacted Mr. Cooper again for fun because we were mailing the payoff to Mr. Cooper. We weren't wiring it. But the beneficiary for the wire being Payoff Processing Fund caused her to ask the question. Mr. Cooper said, we didn't send that. We would never do that. Well, we contacted our bank then again for fun, and our bank said that account had been only open for 5 months and it only had $84 in it. And the owner of that account had no association with Mr. Cooper. So some hackers actually hacked into the fax system before it got to the other title company, changed the numbers around, and then sent the fax again to the title company. They did it like that. So the title company was unaware because their own fax provider had been hacked into, and they delivered us the payoff, hoping that the fraudsters were hoping that we would wire those to the account that was designated, and they would have gotten $400,000. So that's just one example. We all know about the fake sellers for fraudulent or for vacant land. They exist everywhere. The best way to detect and prevent fraud is just by using common sense. Everybody gets the text messages or the emails. They oftentimes use the word kindly. They'll use something that isn't a typical word that we use here in the United States. Or they say, I'm only coming in town for a few days and I want to buy a $7 million property and I want to pay cash for it. Where you have a seller who says, I want you to sell my home and I want you to sell it for below market value and I have to sell it really fast. I'm not going to be in the state though. We've all gotten those texts. They're pretty obviously fake, but they're always getting better. So the best thing you can do is just common sense. Does this seem like a normal transaction? If it does, then great, continue going forward. Our common sense has been elevated just because we've seen the different tools and devices that they use to try to perpetrate fraud. So we look at it from a little bit different perspective sometimes, which is great because we complement each other. You're looking at it from, does this buyer or seller act like most of my other buyers or sellers? If not, can I explain why there's a difference here? And on our side, we're looking at it saying, the 2,500 transactions we close a year, does this one contain the typical things that we're seeing, the typical interactions with buyers or sellers that we have? Here are a couple different platforms. So we use Quality Shield, we use Safe Validation, and we use Certified. Quality Shield, the buyers and sellers, they don't like these platforms. Bottom line is they don't like them because it's a pain. You have knowledge-based authenticating questions they're going to ask. Everything from, hey, what kind of car did you drive 7 years ago? Pick from this list of four. Which of these zip codes do you recognize? And some people can't remember them. It's a pain. And it's a pain because they're legitimate sellers or buyers and they know that they haven't done anything wrong. But given the fact that even one transaction could put us out of business, could cause you to file for bankruptcy, and I say you, I mean you as agents, because you get sued too. And then whoever the parties are that committed the crime, they're long gone. So it's the agents and it's the old owners who are going to be responsible for facing the music on any claim that's being filed. So these different platforms, they don't take very long, but they're extraordinarily helpful. For example, Certified works directly with the Secret Service. So we use them because from a recovery standpoint, they're the gold standard, but they're all just trying to use things like facial recognition, look at your driver's license, marry it up with your bank account to make sure that you are who you say that you are. So although it's kind of painful, it's actually objectively not painful, but I can see when they have 6,000 other things to do that it can be painful. But just that's where, as an agent, you have to remind them that that the title companies are doing this for their protection. That they're doing it so that the we can remain compliant. Even if we know that somebody is legitimate, we still have to run them through certified or shield. We have to. We don't have an option. That's because we have a contract with our underwriter to serve as a title agent. So underwriters are the ones who issue the policy, but they use title agents to use those. It's just like any, call it homeowners insurance, call it auto insurance. You go to State Farm and you have State Farm who is an agent who's able to write a policy for the insured. Same thing. Momentum Title is an agent for First American and an agent for Fidelity. But those underwriters require title agents to go through either Shield, certified, closing lock, some current technology, some approved industry standard technology that prevents fraud. So even if I know someone is legitimate, I still have to run them through because if we get audited, then it's going to show that we don't have our Shield validation, we don't have our certified validation showing that it was legitimate, and now we get in trouble. So there are exceptions to it. You don't have to do it every single time. You just have to prove why an exception is necessary. And so don't worry if for some reason your clients were to fail certified and shield because they do have false positive rates. We can still work with them and get it closed out. Standard and enhanced policy is one we're going to spend just a few remaining minutes on. And this is because things have changed. Things have changed for the better for your clients. Here are some of the things. We're all used to having a standard policy. And historically, we've never pushed for an enhanced policy. We didn't think it was good for the buyer. Certainly good for the P&L. I mean, the enhanced policies do have a 20% higher premium, but we just never thought that the consumer was getting the benefit of those. The analogy I use is if you go to buy a new car, you have the cost of the car, and then you have all these different add-ons for roadside coverage and for extended warranties, and you name it, they're going to put it on there as an upcharge. And some customers say yes, but they actually never get any benefit from it. They pay a lot, but they never get any benefit from it at all. Well, and that's how we used to put enhanced policies. We thought we're not getting a whole lot from them. But now the enhanced policies, First American calls theirs an Eagle policy. Other title companies call it, underwriters call it an enhanced policy. And then Alta has its own homeowners policy that is now part of the benchmark contract, but it covers things that occur post policy issuance. So it sounds like I completely contradicted myself because earlier on in the presentation, I said the title insurance looks at the closing date and looks backwards to determine what the coverage is and what the risks are to issue a policy. Well, that policy is going to cover any claims that are made based on pre-policy events. So before the closing date, that's what a standard policy is going to cover. Things that arose prior to the closing date, but the claim was filed after the closing date. That's the standard policy. Enhanced does the exact same thing, except it also now provides for an expanded scope of coverage. So if there's some post-closing forgery of a deed or forgery of an easement or forward of any memorandum that gets recorded with the Registry of Deeds, something that did not exist on the closing date, it's now covered. if your next door neighbor decides to build a structure and that structure now is going to be split in your boundary line, even though the underwriter can't control what neighbors are building and where, well, there's now coverage for that so that a buyer doesn't have to then get into a lawsuit with their neighbor about the boundary line where there are no attorney fees can be recovered, but just in order to go talk to a lawyer and get a lawsuit filed, it's going to be $2,500 or $5,000, not worth it to them. Well, now they just make a claim with the underwriter, and the underwriter says, okay, you got the enhanced policy, you're covered. And then so for the cost of the owner's policy, $84 up in the previous settlement statement that we had, or a couple $100. Well, they can now get, since the simultaneous rate is going to be lower, they can now get a lot of coverage just for that little 20% of an increase. I say little because we're not talking 20% of 10,000, we're talking sometimes 20% of a couple $100. So now all of a sudden the underwriter is stepping in to say, we'll provide you complete coverage and don't worry about this going forward, because instead of you paying $2,500 to a retainer just to get the lawsuit started, we're going to defend you for free the entire time. It's free because you've already paid for it. Subdivision violations. If there's an HOA, declarations, covenants, conditions, restrictions, if there are those, then and there's a violation of those, it's covered. Restrictive covenant violations, again, that's covered. Encroachments for boundary walls or for fences, covered. So there's another, I didn't include it on here, but I am going to send everybody who signed up today, just send a very nice broken down standard versus enhanced check marks for what's covered and what's not. Last thing I'll say before we turn it over for questions is the hot topic of what title companies don't do with respect to use. A title policy does not guarantee how you use the property, period. If you're going to be operating a business or operating a meth lab, it doesn't matter from a title policy standpoint, because we're just looking about whether or not you have insurable title of the property, whether or not we think that it's clear and marketable enough to issue a policy on. That's the actual dirt that exists, not your use of that dirt. So whenever we get, say, an HOA or a subdivision, hopefully every agent is looking at this property is in a subdivision, and you're finding what those declarations, covenants, conditions, restrictions are. And you're looking at, if it's an HOA, you're looking at the bylaws and you're forwarding those to your client. I say that because since the title policy doesn't cover your use, and the buyer's use is going to be governed by the DCCRs and the governing documents for an HOA, we don't look at those. And we also don't provide those because, again, it's not part of our role. We certainly can because they're built into that search. We just don't go showing them to every buyer, because then there's another conversation then where we can't give advice on how they're going to use the property, because we're not a law firm and they wouldn't want to engage a lawyer. We just assume that either the agents have found those or the borrowers themselves, the buyers themselves, have contacted the HOA to get a copy so that they know what they can and what they can't do with the property going forward. If you want those, though, by all means, they're very easy for us to provide. We just don't do it because it oftentimes creates complication and confusion, and it creates some inefficiency. But we're happy to talk about them. So if you do get some DCCRs and just have questions about them, we have 5 attorneys, and we're all the time not giving advice, but we're giving opinions on how we think certain things should be construed or not construed. So just ask us for those. Happy to provide them, and then also happy to have a discussion with anybody going forward. That's the last slide. Questions. I know that I'll put a quick plug in here is that if you haven't used this before, please, we'd love to have the opportunity. We always have the first closing where the settlement fee is waived as a benefit for your client. And so that's a tryout. If you enjoy the process, we'd love to work with you more. If not, we'd love to get your feedback on how to make it better. We do offer discounts for active duty, for veterans, for firefighters, for police officers, those first responders. And then if it's your personal property, the settlement fee is always going to be waived there too. But besides that, we are located in all but just a few of the offices. We're located in Clarksville, Mount Juliet, Murfreesboro, Franklin, Nashville. So we're there. We're looking forward to working with you. And if you have any questions, let's go to those right now. And I'll end this slideshow. Let's see if we can stop sharing. All
Griffin,
right.
the first question came through. If someone closed with standard policy, can it be upgraded at a later date or only at closing?
It can be updated very close to closing. I say very close because there's no actual, and I'm done sharing screen, or am I still sharing it? How do I
You
see?
are still sharing.
All right, how do I, it doesn't even have a button to stop share, but, oh well. Um, if it's not bothering you, then it's not really bothering me.
It's
So
not. Down at the
yeah,
bottom, it should say where you had the option to share. It should say stop sharing.
oh, there you go. Great. Base is back on. So you can always do it right before closing, for sure. Of course, you can just do that on the closing day itself if you wanted to, because the policy hasn't been issued yet. Policies are typically issued within 60 days. And so as long as we're pre-policy issuance, then the answer is yes, no problem. We always invite people to try to do it. It's just once the policy is out, then it's a little bit more difficult to do it. And that is because then the buyer has to sign an affidavit saying, I'm not aware of any claims. What the underwriter doesn't want to have happen is somebody closes and then realizes that there's a problem that would be covered under the enhanced, and then they try to migrate their policy over from a standard into an enhanced. The insurer underwriter is going to make sure that there is no claim, and that if a claim ever did arise and it was for during that gap period from post closing until enhanced policy migration, then it would not be covered. So I would say if you have one, then you have a standard, then you could upgrade it as long as you're not too far down the road after closing.
Cool. Next question regarding post policy slash enhanced policy circumstances such as HOA and boundary line disputes. What does coverage, in quotes, actually mean in practice, such as
Mm.
reimbursement of lost funds, attorney rep, and other actions?
Yeah, so there on a few of those, there is a deductible. It's a pretty small deductible, but I think, let me see if I can do this right here. The easiest thing in that situation is for me to send out a just the primer. Let me do this again here. Shares. All right. So everybody can probably see this here. Here's the description. This is from First American of what the standard versus enhanced is. So you come down here and you can see what's covered. Unrecorded easements is one that I mentioned. There's a lot of coverage here. Um, it's a no-brainer at this point. It's a no-brainer to have the enhanced. I did it. I never, even though I'm the owner of a title company, can see the entire record. I always get title insurance, and I never ever purchased a property without getting enhanced at this point, just given the 20%. But to your question, Katie, is that it depends. A lot of those events that are mentioned on here are full coverage without any additional deductible, and every one of them is for the life of the ownership. So it's not like there is an insurance policy that you have to keep renewing year after year. It's a one-time amount, and it's good in perpetuity until you transfer the property. There are a few things that have deductibles, and you can see those that are with the asterisk there. I think if I recall right, the asterisk, yeah, a deductible and then limits apply. The limits are high enough that I haven't seen any limits where I'd say, oh, that's not really much coverage. So I would not worry about from a limit standpoint, but I would just think that there's a little deductible that's going to have to be paid for all these that have the asterisk. And I believe the last time I checked is that the deductibles range depending upon what the claim is, but it was 250 to 500. So nothing that's going to make that cost prohibitive either. Still less than the cost of an attorney.
Okay, next question. What's the best way to get a quote for raw land with no address?
Find an address in that county and just plug it into the title calculator. Because again, since rates are based on they're based on the amounts of the coverage, they are address agnostic. So these title calculators don't care what the actual address is. All they really do is they care about what the county is. So if it's raw land, it's going to be from a rate standpoint, it's not going to be any different than if it's residential. So I would just plug in any address in that county and then plug in if there's going to be a loan. If not, if it's going to be cash, put that amount in, designate who's going to be paying for it, and then hit get quote and you'll get it instantaneously.
Perfect, thanks. Okay, Gretchen Jolly has 4 questions. They're all good
Four,
ones.
Gretchen. Sheesh.
The first one, does a buyer need to get a survey or obtain a survey in order to have coverage for a boundary line or encroachment issue slash dispute on title policy?
No, but it does. So only caveat to that is that if there is a post, no, because it would not have been revealed in a general title search. So I'm sorry, in a survey. It's a good question. I'm going to take a note on that so I can get back with you, Gretchen, on to determine whether or not I think the the bottom line is no, because if it's a platted subdivision, then obviously you're going to have a plat map, and the plat map can only exist if there's been a survey. And then if you have another property that just has a meets and bounds legal description, that's what's being insured. So we don't insure addresses in Tennessee, we insure legal descriptions. So if there is a post-closing boundary line dispute where someone has then decided to encroach over the meets and bounds as determined by the legal description, then that would be covered.
Okay.
What
You
was this?
mentioned sending contracts into orders at Momentum Title. The question is that the preference if folks have historically sent directly to their processor?
That's fine too.
Okay.
We like to see it go through orders. It's whatever's easiest. It's just because there are several people that have the orders emails, and those don't get moved out of the orders inbox until they're assigned. And so I would hate to have it happen where an email goes directly to a processor and it goes to a spam filter. But if you have that good dialogue, that good conversation with the processor, they usually respond by saying, "Got it, thanks," or they will ask you questions right away. So if you're used to going through a processor directly, that's completely fine. Orders is just more one where I'll get to them, but there's a step in between.
Okay. The other questions are something I think we'll probably, you and Scott and I can have a conversation around. Can your ideas of special steps, language, title, and otherwise, for suggested items be loaded in transaction desk? And then the final question was around having a handout for clients as to what they can expect from Momentum Title so that they know communications are not fraud and that they expect the process. Agents can explain, but if they have something to refer back to, it would be nice.
Sure. Yeah, there's a one-page sheet, try to get it on to one page where it just says what you can expect during the process, and it has contact information for those people that they're going to need to talk to, and it has our information on there too. So I can send that over to you, Katie, if you wanted to blast it
Yep.
out to the others, or I can do it myself.
Yeah, we had a question about whether this recording would be made available, and it will be. We've been recording. Give me a day or two to get it up on the dash and get with Griffin to get any other resources, and we'll kind of put it all in one place and make sure everyone can find it. All right, last call on questions. If there's anything else, Victoria said no questions. Thanks for doing this. Thanks for being here.
Thank you all.
Oh, Brian Kolb,
Oh,
do both title companies in a transaction order a title search? Good question.
Brian with the last question, going out in flames. Love it. I was hoping that split closings wouldn't come up because I can't stand split closings. The short answer is 99% of the time, yes. I'll give you the time when it doesn't, when both title companies don't do a search. The reason that we have split closings is goes back to the 1900s, late 1900s. And it was a way for title companies to actually split the policy revenue and the settlement, or they have their own settlement fees. But it's a split of the revenue in addition to a split of the liability, in addition to a split of some of the obligations. Almost all title companies split. There are a few that do not. If a title company does not split, the other title company will not order a title search. Why? That's because the other title company that's not splitting is issuing the policy, and we're not splitting liability, so we're not going to incur any of the search fees. We're just going to go through the closing process, but we're not providing any guarantees or warranties to the buyer about the effectiveness of title. So you will only see one search fee if there are two title companies involved and one of them doesn't split. So that's common. Or two, if we have First American as our underwriter, they have what's called a step program, where if both of the title companies are using First American, it's only one search. And then we can split that search fee in half. Otherwise, you're always going to have two title companies, each of them ordering a search. And that's because we're splitting the premium, but we're also splitting the liability. And we're never going to trust another title company search. We want to independently make sure that it's as good and marketable as it possibly can be. And so we do order our own search, because that search also gets us a title commitment. And that title commitment tells us what the requirements are, what the exceptions are, for us to be able to insure and assume the risk, even if it's a split risk. So yeah, I think that's that answer it. Brian and I, you can always shoot me a text.
All right, that is all the questions.
All right. Well, thank you all very much.
Thank you.
Bye.